Thank you. I'm reminded of a story about one of my favorite figures of the Revolutionary War, Colonel Ethan Allen. Just after he was beginning to retire and he was finishing up a good career at the State Department in the early part of the 19th century, he was dispatched to the United Kingdom to negotiate a trade deal. And in order to try to get the best of him, his counterparties in the negotiation hung a giant portrait of George Washington in the privy, in the outhouse. And every time he would return from it, they would sort of wait for a reaction and hope he would get him hot, and he would sort of mix him up in the negotiations. But he wouldn't let him show. He wouldn't let them have the satisfaction. And eventually they asked him. They said, "Colonel Allen, whatsoever do you think of our portrait of your leader?" And he said, "Well, I rather think it's appropriate, and I rather think that's the only place we can hang it." They said, "What do you mean?" And he says, "Well, in my experience, nothing makes an Englishman have need of the privy quite so quickly as the sight of General Washington." And so I wonder if perhaps, as part of the solution to the moral hazard problems of bailouts, we might have a new policy to hang a portrait of Ken Feinberg and Secretary Paulson in the executive washrooms at Bank of America and GM and some of the other TARP recipients. And I think that's a policy that I think I could actually support. So in some ways, I'm a bit of a strange invite for this panel because I'm a pure corporate guy and securities guy, and so this is an administrative law panel. And many times over the last year, I've found myself feeling like I've taken a wrong turn on the scholarship highway and coming up against constitutional law and administrative law questions, and I think that's going to continue. And I think guys like me are going to be interacting with guys like David a lot more often, which in David's case is good. In my case, it's good with David. Maybe not necessarily everyone in the field that's not nearly as interesting as corporate law, I would say. But there'll be much more interaction, and I think this comes from the fact that the government's ownership in TARP recipients and the government's very powerful ownership in TARP recipients. Now, the government owns common voting equity in GM and Citigroup. The government owns preferred shares in the other TARP recipients. And the government owns common equity also in GMAC. Now, I would say that the unique thing about this analysis is that the government has become effectively a control shareholder. That's a very special term in corporate law, and it's something that you don't want to be. Control shareholders are treated very specially by corporate and securities law, and they're reviewed, their actions are reviewed very significantly. Now, how do we determine control for this purpose? Well, percentage ownership is where we begin, but you certainly can have control as a sub-majority owner. And so I think, for instance, at 34% for the government's ownership in Citigroup, I think it's a very easy case to say that the government's a control shareholder there. I think it can go even lower. Courts have looked to, for securities cases and corporate cases, co-status as a creditor, and I think that obviously would apply very easily to the Treasury Department. I think the unique thing about the government as a shareholder is that it, of course, also regulates these companies, and that's something other shareholders aren't going to do. It makes the analysis a lot more easy. And I think we can make a colorable claim that even at sub 10% ownership, the government can be exercising shareholder control. This is very difficult under corporate and securities law. If you are a control shareholder, you have the same fiduciary duty, it turns out, as the board of directors and the executives of the company to the other shareholders. To maximize shareholder wealth. Under securities laws, you have joint and several liability with the company for violations of the securities laws. So control shareholder is not a fun status to have under those aspects of the law. The unique thing that the government gets, though, is sovereign immunity. And so that really changes the dynamic completely. It makes it very difficult. Now, the analysis on whether sovereign immunity attaches to the government's exercise of shareholder power is it's extensive, and I haven't even fully answered all of the unique questions that come out there. I've got a paper on this, Treasury Incorporated. I'll make a shameless plug for. You can Google it and go take a look if you want more of this. But I think while there might be some cases where a clever plaintiff's lawyer might have a fighting chance, the sovereign immunity protections for government's exercise of shareholder power are pretty firm. I think it'd be tough to make a claim under the Tucker Act, the Tort Claims Act. Beyond that, the Emergency Economic Stability Act is quite clear about a broad reservation of sovereign immunity protection, and also Section 3C of the Securities Exchange Act explicitly exempts the U.S. government from application of the 34 Act, of the act that includes, among other things, the restriction on insider trading. Now, there are some strange consequences for corporate theory that come about with the government's ownership. I'll skip those for now and save those for the panel across the hall, the folks at the panel across the hall to talk about at maybe a later date. But in terms of corporate practice and the odd occurrences that happen when government is an owner in private companies, first of all, with respect to insider trading, you know, a bureaucrat at the Treasury Department is perfectly free. The folks at the Financial Stability Office at Treasury are perfectly free to engage in insider trading on the TARP shares that they own in Citigroup and all the other TARP recipients. Completely immune from insider trading liability. Now, far be it for me to be a strong advocate of insider trading. My law school was founded by a guy who made his name developing scholarship about how insider trading might at times be efficient. But I think in a world, we can all agree in a world where insider trading is illegal for everyone else, it's going to cause some significant economic distortions for one very strong shareholder to have an immunity from insider trading liability. Deal approvals might become difficult because when you have a controlled shareholder, corporate law considers that you don't really necessarily have independent directors, and independent directors can be very important for improving deals in mergers and acquisitions, and so that might become difficult, I think, going forward. Affiliated sales. This is another thing that sovereign immunity won't protect against because it's not the government that would be the target of this sort of action. But affiliated sales, for instance, if Bank of America or Citigroup held Rule 144 securities, exempt securities, in GM and wanted to sell them, the fact that they share a control shareholder, at least in my view, would make them affiliated sales. They're very difficult to do. You have to register affiliated sales. You have to deliver proxy statements, and it can be very expensive. The penalty for not fulfilling all your obligations there is rescission. So that's much higher damages than you get anywhere else in securities law. If I were not in this business and in the plaintiff's law business, or maybe if I don't get tenure, I'll go into this business, I would frankly try to find some buyers of Rule 144 securities and seek rescission damages. I'm surprised we haven't seen that yet, frankly. Class actions, right? CalPERS is a lead plaintiff in a lot of class action litigation. Is Treasury going to do that too? Or are they going to join it? Or are they going to lead it? There's quite a conflict there because Treasury has an interest in propping up these banks at the same time. Are they going to farm it out to who? To plaintiffs' lawyers? They're very big in terms of political contributions, so that could get a little bit sticky. Right? Are they going to let the DOJ do it? Are they going to let the SEC do it? A lot of class actions piggyback on SEC enforcement actions, so how exactly is that going to work? But overall, I think the broad, really, question is off-balance sheet subsidies. I think when we see governments do things that don't necessarily comport with long-term wealth maximization, it's the sort of things, the problems that we see at Fannie Mae and Freddie Mac that a lot of folks have studied for 10 or 15 years and that Peter Wallison has been warning us about from the very beginning. And I think the way that we look at that is going to change. And I think that brings in also issues about federal budgetary policy and whether it's a good idea to bring more of the debt and liabilities and also the assets of TARP recipients onto the federal budget. I mean, in private sector accounting, if a parent controls a subsidiary, there are rules requiring that parent to bring that subsidiary's books onto the parent's books. So I think now that government is acting like a private investor, the lessons of private sector accounting, I think, ought to apply. Questions I would pose for administrative and constitutional law going forward. What happens when the government uses its shareholder power to implicitly regulate? Sort of like I'm a fan of the Godfather movies, and what I learned from that is that the best kind of power to have is the power where you don't even have to ask people to do things. They guess what you want them to do, and then they go ahead and do them. So what happens for administrative law there? How can you FOIA request a CEO deciding to do something because he figured Treasury wanted it to happen because it's an election year and maybe making cheaper loans in battleground states is probably what Treasury wants us to do, and maybe we can get better loans from Treasury in the future because of it.